12:59. Okay, so I'll introduce myself because that's not too terribly important. I'm Kim Velk. I'm the Director of Education and Communication here at the Vermont Bar Association. Um, Glad to have you all here today. We're doing an hour-long CLE with Dr. Gleb Sapersky. This is one that will qualify for that DEI credit if you're looking to relicense at the end of this month. Um, this is the second time we've had him teach us a course. Uh, he contributed an article to the fall issue of our Vermont Bar Journal. That was this one with the dogs on it on valuing emotional injury. And then he taught a CLE on it. It was very interesting. So if you want to find out a little more about the kinds of things he knows about, you can grab your fall issue. And then he did another one for us on the topic we're discussing today that's in our current issue, which you all should have by now, if you're VBA members, on this topic of debiasing the law, understanding how cognitive biases leads to a more just legal system. All kinds of interesting psychological insights I think we're in for today. Um, he has an interesting and diverse resume. He can tell you more about that. He's an author, a consultant. He's been an academic. He has a PhD in the history of behavioral science from the University of North Carolina, Chapel Hill, a master's degree from Harvard, and a BA, is that right, from NYU? Did I
Yes,
miss anything?
that's
Uh,
good.
he teaches around the country. He's um, very well informed, interesting guy. And I will stop talking and let him take over. And thanks everybody for coming. It doesn't mean we don't want to hear from you, that I've asked you to mute, but you can throw questions in the chat or raise your hand or whatever if you have comments or questions. Is that all right with you, Dr. Glab? I can help keep an eye on that chat.
Sure.
Yeah, okay. Okay, so
Sounds
take
good.
it away. Thank you.
Thank you, Kim. And thank you, everyone. So let's talk about debiasing the law. And we'll talk about some cognitive biases and how they impact the legal system. Now, if you're present here, you should be able to get a copy of my book on which this presentation is based, The Blind Spots Between Us, How to Overcome Unconscious Cognitive Bias and Build Better Relationships. That's about debiasing. Another one called Never Go Their Gut, How Pioneering Leaders Make the Best Decisions and Avoid Business Disasters. Those are not trying to sell those books. Those books are, you will get them for free as an email after this presentation. So if you're present here, so I'm just letting you know. If you're not currently present here and watching this as a recording, in order to get those resources, in order to get those books, my slides, and some expert witness reports, oh, I'll send those too, you should go to the link under my name. That's going to be tinyurl.com/DAEEVENT. Again, tinyurl.com/DAE event. So tinyurl.com/DAEEVENT to get the resources from this presentation, expert witness reports, and copies of my book. So that's just so you know, and get that out of the way. All right. With that out of the way, let's talk a little bit about logistics. Now, you'll be able to see my slides on the screen right next to me. So you'll be able to see them changing. You want to make sure to make your Zoom full screen so that you're actually fully able to see the slides, otherwise they will be cut off. So in the top right corner of your Zoom screen, you'll be able to see a view button and you click on view, then click down to full screen. That's going to be the bottom button. So click view full screen so that you'll be able to see my slides. All right, I think that's pretty good. So let's talk about debiasing the law. And the first thing I want to talk about is the framing effect. How is information framed to us? So how are you thinking about the information? How are you presenting the information to the jury, to the judge, to the trier of fact? How is the information being presented in general? That's a very important conversation. That's something that people don't think about sufficiently because you think, well, I present logical information, factual information, but sometimes the way it's framed is the key. I'll give you an example. So, very simple example. Let's say you have two types of ice creams. So you go, you open up the fridge, the freezer, you see that there's two types of ice creams. One says 10% fat, so an ice cream that contains 10% fat. Another is 90% fat-free. So 10% fat or 90% fat-free. Which of those do you prefer? Which of those sounds more appealing to you? Take a couple of seconds to decide. Now, if you're like most people, 90% fat-free is more appealing than 10% fat. And let's think about that. It's not fat-free, right? Sounds good. But if we think about 10% fat contains 10% fat, that's the same thing as being 90% fat-free. 90% fat-free means it has 10% fat. 10% fat means it's 90% fat-free. It's the same information presented differently, but one of those sounds much more appealing. So, how we see and interpret the world is determined by the frames for which we see it. So think about how various framings of legal cases might shape the way the information is interpreted by the trier of fact. That is very important. So this is something that, again, I don't think gets thought about sufficiently, doesn't get talked about sufficiently. Okay, so that's the first thing I want you to think about. And I want you to think about take the next few seconds to think about and write down where in your legal work you might consider the impact of the framing effect. How information is framed to you, to others, and how are you framing it when you're communicating to the relevant parties. All right. Now, let's talk about another example. And for this example, I'll do a screen share. Now, you might remember the famous O.J. Simpson trial. And if you remember the O.J. Simpson trial, you might remember this really famous moment from the trial.
O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit.
Okay, so hopefully you remember that moment from the Dream Team presentation by Johnny Cochran. Very famous presentation, very famous element. And that's something that was perceived to be particularly impactful in getting O.J. Simpson acquitted of at least of the legal case, not the civil penalties. And so this relates to a concept known as the rhyme as reason effect. If it doesn't fit, you must acquit. And so when words rhyme, or more broadly, when they're cognitively easy, cognitively fluent, they're more convincing. So phrases, thinking about the phrasing of, right now, generative AI is a big, big tool that many lawyers are using. And one of the things that generative AI is not quite good enough yet to compete with lawyers for is good phrasing. But some lawyers aren't really as good as they can be at phrases that create cognitive fluency. Phrases that are cognitively fluent means that they go down easily. They feel natural, they feel intuitive, like a rhyme or a metaphor, something that is easy for our brain to process. That makes it more believable. If it's easier to process, it's more believable. So that is something that is maybe counterintuitive to you as a lawyer. It should be logically reasonable and think something that's rational. But it's really not about reason or rationality. It's more believable and it creates trust if it's cognitively easy, if it makes our brain feel that this is natural, this is the right thing. And what's going on with the framing effect? What's going on with the rhyme as reason effect? that cognitive fluency, that presentation of information about the ice cream. The thing that we need to remember, that you need to remember as lawyers, and is critical. I mean, I do a lot of expert witness work, and I see this all the time, that most of our decisions come from our emotions, how we feel, not how we think. We vastly underestimate the role of emotions in our decision making. Recent studies show that emotions drive 80 to 90% of the decisions that we make. When we just go ahead and make our decisions in a way that's very natural to us without using the kind of evidence-based decision-making strategies like learning about cognitive biases, such as the framing effect and the Ramos reason effect, and watching out for them and learning about how to incorporate them into our legal work. So this all leads to bias, discrimination. These are problems. And there are two types of bias that I want to talk about. One is explicit bias, where decisions are based on prejudiced and preconceived choices. That's explicit bias, where people know that they're biased and they're deliberately making that decision. But however, most forms of bias that we see in our current society, not all of them, most of them are implicit. It has to do with people not realizing that they're biased and they're failing to prevent themselves and others around them from falling into these implicit biases, like the Ramos reason effect and the framing effect. And that leads to poor decision making, really problematic decision making. It's vital for many fields of law. Employment law, obviously, when you're dealing with employment, that's going to be a huge area of potential for discrimination. Public procurement, major area for where bias can play a role. Jury selection, when you're selecting jury members, you really need to think about what kind of bias folks are likely to have. Criminal defense, huge area, of course. That's a big area where you want to think about these issues. Business decision making, when you're dealing with bankruptcy cases, mergers and acquisitions, a lot of bias can come in. Bankruptcy, also specifically a big area, not only of business decision making, personal decision making. Police misconduct is a huge area that you want to be aware of. And of course, many other areas. So let me give you an example of a specific area that a specific case that you might want to think about. And this is a case I'm working on now, or this is a case I worked on. So this is a case, you can look this up, of it's Pauletta Johnson and Shakira Hill versus the Unified Government of Wyandotte County in Kansas City, Kansas. This is the case number. I'll send you the expert witness report after this presentation. So, what are the facts here? So, a young black man was shot by a Kansas City officer during a traffic stop. He was conducting DoorDash deliveries, and after complying with initial requests, Mr. Henderson, the young black man, became anxious because the officer had some pretty escalating and confusing conduct, and he called additional police units. So Mr. Henderson attempted to drive away from the scene. Officer Schuler reacted by recklessly jumping under the vehicle and firing two shots, killing Mr. Henderson. And so this is the nature of the lawsuit here. So this is a police misconduct lawsuit, in other words. So let's go into some of the cognitive bias assessment that's going to be relevant here. So looking at the kind of biases that could be seen in Mr. Schuler's, the police officer. So the police officer is Mr. Schuler, the deceased is Mr. Henderson. So we talked about Horn's effect, where negative traits cause individuals to negatively judge other unrelated attributes, anchoring bias, where you tend to rely excessively on initial information, confirmation bias, look for information that confirms your belief, empathy gap, where individuals underestimate or fail to appreciate the emotional states of others whose perspectives they don't share intuitively. And so, here I talk about Mr. Schuler's conduct, and Here, I specifically give examples of how these cognitive biases were impacting the officer's conduct. So he appeared to fixate on a negative attribute, likely, possibly Mr. Henderson's race. We can't know for certain, but given Kansas City, Kansas Police Department's history, race appears as a likely candidate. Anchoring bias. So initial hostile perception anchored all subsequent judgments. Confirmation bias, selectively interpreting any behavior to confirm wrongdoing. And lacking empathy for the experience of young Black people stopped by police, Schuler, the officer, underestimated the effect of overwhelming fear, confusion, and medical vulnerability. So Mr. Henderson had asthma, for example, and he was especially anxious as a result of the situation with George Floyd protests and I can't breathe and so on. And so Schuler acted in a pretty highly problematic way where when Mr. Henderson, in a panicked state, attempted to drive away, he jumped on the car and shot Mr. Henderson in the face. And so that is definitely against standard police conduct procedures. And so my remit here is to look at Mr. Schuler's conduct, Officer Schuler's conduct, and explain how the biases impacted that conduct to help the jury understand the nature and the psychological elements involved in police wrongdoing here. So that's one element that I want to show you. And so that is for the plaintiffs. Let me share with you another expert witness report where this is more about me looking at and where I'm for the defense. So that was me as an expert witness for the plaintiffs. This is me as an expert witness for defense counsel. So what's going on here? This is about a $140 million class action lawsuit against the city of Annapolis, which it's alleged that the city of Annapolis is discriminating against residents. So the city of Annapolis and the Housing Authority of Annapolis are alleged to be discriminating against the residents of the Housing Authority of the city of Annapolis. I'm sorry, are alleged to be discriminating against the residents. And the residents are poor, African American, disabled. So the claim here is that the city of Annapolis is not doing sufficient inspections. And the argument is that the city of Annapolis is not doing sufficient inspections comparable to how it would be doing inspections for the private housing. And so the argument under fair housing law is that it's a disparate impact, that it's because it's a disparate impact that what the problem is that they are not creating a sufficiently safe environment for people who are residents of that housing. There's molds, vermin infestation, and so on. Now, I found that there's no statistical evidence that the city's policies resulted in a disparate impact. Talked about harm reduction. And the crucial thing, so I talked about, I'll move on to the most important elements here. So the occupancy rate for HACA properties, that's the housing authority, was approximately 82%, which indicates a substantial number of vacant or unavailable units. And there are a bunch of people on the waiting list who are seeking housing. That underscores the significance of balancing current residents' needs with the needs of those awaiting placements. So HACA, the housing authority of the city of Annapolis, struggled to address widespread maintenance and structural constraints, Even basic repairs were postponed. That explains why inspections were not done so as rigorously as they would be done for private housing. And so the key here is a framing effect. So thinking about framing. The city of Annapolis, I'm arguing, was not discriminatory. The plaintiffs present the policy as an act of neglect, and they are only focusing on the people who are currently in the housing. There are approximately 1,600 residents. Now, if that's the only population who we had to think about, that would be a not unreasonable argument. They're saying, well, the city should have done more inspections, specifically of the people who are, and provided them with a safe environment. But there are also 1,700 individuals on the waiting list who depend on the continued availability of public housing. So, if the city imposed inspections without the funding from HUD, which is not the city's responsibility, to conduct necessary repairs, the inevitable result would have been widespread unit condemnations, displacing current residents and ensuring that those on the waiting list would never receive housing. This alternative, forcing hundreds of African American disabled individuals on the waiting list to spend more time in homelessness by reducing the city's affordable housing stock, would have been the actual discriminatory disparate impact compared to the city's actual policy. So, the point here is when you're doing a disparate impact analysis, you want to think about the framing and you want to think about what is the actual nature of the discrimination. So given the limited nature of public housing resources, which it's not the city's responsibility to provide those, it's the responsibility of the housing of HUD, the federal government, which was underfunding public housing. Given that they didn't have enough resources to repair every minor thing, so they could have repaired every minor thing and then maintained high quality housing for the existing residents. That's one option. But then a bunch of the units would have been unavailable because they would not have had the resources to have people in those units. And so they would have put the people who are on the waiting list, who are also the same population of African Americans, disabled people, and so on, they would have been homeless. So you have to make a trade-off. Is it better for people to live in housing with chipped paint and mold and so on? Or is it better for them to be out on the street? And the large majority of people would choose to be that they're better off living in housing that's with chipped paint and missing window screens and moldy and vermin and so on, rather than living out in the streets. And I provide later in the expert witness report, I provide extensive evidence of that. And so this is an example of doing this disparate impact analysis for discrimination in a $140 million lawsuit using the framing effect. Like, what are you looking at? Who are you paying attention to help make the right decisions about a major legal case? And by the way, if at any point you have any questions about any of these cases or anything else, just pop them into the chat. All right. So what's the problem here with decision making going with our intuitions? Well, the problem with going with your gut is that gurus tell us that going with your gut and trusting our intuitions and following your heart is the right way to do things. Trusting our gut feels very comfortable, but it often leads to disastrous decisions because our gut is not evolved for the modern world. It's evolved for the savanna environment, the ancestral savanna. When we lived in small tribes of 50 to 150 people, it was very important to be loyal to our own tribe. If you weren't sufficiently loyal, your tribe might kick you out and you would die. And it was important to be hostile to other tribes. Otherwise, another tribe would take over your tribe and you would die as well. So we descended from those who didn't die. So we are wired to be tribal. We are wired to discriminate, in other words. And so you have to think about how are you going to address that intuitive tribalism that we have? And looking at that disparate impact analysis, whether you're looking at a disparate impact analysis and which group are you paying attention to, or you're looking at Officer Schuler's conduct and trying to help the jury understand why a police officer engages in misconduct so the jury comes to the right conclusion about that topic, those are the things you need to be thinking about and aware of. Another thing to think about is this fight or flight response to threats. It was life-saving for hunter-gatherers because the risks they faced were immediate, intense in the moment. Saber-toothed tigers. Just like Officer Schuler was facing that risk. But it's dangerous in today's world. The risks we face are long-term, uncertain, like notification on our smartphone about a disease starting in the middle of nowhere, China. And so those are the things that you want to think about. There was another officer on the scene who, instead of jumping into the car when it was starting to move to drive away, he stepped back from the car. And Officer Schuler had all the opportunity in the world to step back from the car. And so those are things you want to think about. How are you trained to respond to threats? There's a reason that police officers given training. They're supposed to not respond with their intuition. And so it's a real problem when people respond with their intuition. That's when they fall into these dangerous judgment errors called cognitive biases, combination of our evolutionary background and how our brains are wired. So I want you to think about the topics we talked about so far, whether the police misconduct, whether the Fair Housing Authority case, and think about how they can apply to your own work. So take a few seconds to think about that. All right. Now, let me answer a question that a number of you might have been thinking about when you heard me speak. Not when you saw me, but when you heard me speak. Where are you from? I'll be happy to tell you. So my background is my dad is Ukrainian, which is unfortunately way too well known by now. My mom is from Moldova, which is a small country to the southwest of Ukraine. It's so small that you need an arrow on the map to point to it. And I was born in 1981. 10 years later, in 1991, when the Eastern Europe was freed from Russian domination, my parents left that part of the world with me when I was 10, and we came to the United States. So I settled in New York City, which is a cultural melting pot, very diverse. And my parents taught me to be proud of my cultural heritage. And so I was living in New York City. You walk a block, you hear a dozen different accents. So I didn't try to get rid of my accent. And I found out later that was not the best decision because of something called accent discrimination. So accent discrimination is a false perception of those with foreign accents being less trustworthy. It's a false perception, but there you are. That's what people feel like. And so that relates to two cognitive biases called the halo effect and the horns effect. The horns effect, you might remember that from me discussing Officer Schuler. So that's when, if you dislike one characteristic of someone, you tend to have too negative view of their other characteristics. It's like someone has little horns in their head. The halo effect is the opposite. It's like someone has a halo on their head. If you like one characteristic of someone, then you'll tend to have too positive view of their other characteristics. And this is, of course, if it's salient to you. The negative implications for legal cases are quite obvious. And I'll give you an interesting example. So this was from a keynote I did in Columbus, Ohio. So if you know anything about Columbus, Ohio, it's the home of the Ohio State Buckeyes. Go Bucks. It's our big rival and we won the national championship last year, which is great. And our big rivals is the University of Michigan Wolverines. And so this is a presentation, this is a closing keynote I did for Horaco, the HR Association of Central Ohio. There's over 100 people in the room from large companies like Bittel and Nationwide, HR professionals who are coming to the annual conference on inclusion. And I'm presenting on this halo effect and the horns effect. And what I'm going to ask them is, whether they will hire University of Michigan fan. So again, Columbus, Ohio, Buckeyes, University of Michigan is the big rival here. Let's see how many of them will hire University of Michigan fan. So, as you know, I'm a professor at Ohio State. I'm contractually obligated to root for the Buckeyes. I'm guessing there are a lot of Buckeyes fans here, you know. Go Bucks, right? Yo, there you go. Now, how likely are you to hire a Michigan fan? See, 3 people. Now, regardless of how we feel about Michigan fans and their poor choices in which team to root for, does that indicate anything about their performance as an employee? No, I know. Come on, that no should be stronger. So I hope the legal implications for that are obvious. You need to think about where the halo effect and the horns effect might impact your case. And again, this is something to communicate to the jury, especially where this might be an issue. And that I was talking about with Officer Schuler, that is something to definitely communicate to the jury and help them understand what's going on in various situations. Anchoring bias. I also talked about that with Officer Schuler. So it's about the way that we get information. How do we get our initial pieces of evidence? The initial piece of evidence that you get tends to be much more impactful than subsequent evidence. So thinking about how information is presented is incredibly important because the first thing that's presented will color everything else. Subsequent evidence is assessed through the lens of the first thing someone learns about the case. That's why first impressions are so key to understanding what's going on. A related problem is the confirmation bias, where we tend to look through rose-colored glasses, which leads us to search for information that confirms our beliefs and reject information that challenges our beliefs. So that is something to really be aware of, that we tend to not look for the correct information. We tend to look for information that is confirmatory. That is a real problem. The jury tends to look for information that's confirmatory. The judge tends to look for information that's confirmatory. Everybody does. So we need to be aware of and work hard to address these cognitive biases. And so I want you to think about where the anchoring bias and where the confirmation bias might be impacting your legal work. Take a few seconds to think about that. In the meantime, I'm going to set up the next video that we'll watch. And again, if you have any questions at any time, just pop them into the chat.
The monkey business illusion.
Okay, so let's go to the video.
The monkey business illusion. Count how many times the players wearing white pass the ball. The correct answer is 16 passes. Did you spot the gorilla? For people who haven't seen or heard about a video like this before, about half miss the gorilla. If you knew about the gorilla, you probably saw it. But did you notice the curtain changing color or the player on the black team leaving the game? Let's rewind and watch it again. Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected events. And that's the monkey business illusion.
All right. So hopefully that's illuminating about our attention. So where's your attention? The attentional bias. The large majority of people, lawyers especially tend to see the gorilla, so it's a little bit more than half among lawyers, but they miss the people who are the person who leaves the team or the curtain changing color. And that's really important for you to think about. These are the people involved, the background context in legal cases are really, really important. But sometimes it's hard to notice what's going on. And it's hard for the trier of fact, the judge, the jury, to notice these things. Because attentional bias causes us to pay attention to what is most emotionally salient, which was very important for the survival in the savannah environment, but not really great for the modern world. So regardless of whether it's the most important thing, we tend to miss other important information. So we pay attention to what's emotionally salient, not what's actually factually really the most important things to focus on. How do you deal with bias in legal cases? Let's talk about that. You need to have a thorough understanding of these biases. So we talked about some of them, and I will send you the expert witness reports as examples for you to look at. I will send you 2 copies of my books, as I mentioned. You want to learn about these cognitive biases. Knowledge is power, because when you know about them, you can start to look for them and you can start to see them in legal cases, in your legal work, and you could see and anticipate what the triers of fact will be falling for. Both the specific biases themselves and the mental framework, what's going on, the tribalism, the fight or flight response that motivate these biases. If you're representing the plaintiff, so again, I do expect work on behalf of plaintiffs. Something like 70% of my cases are on behalf of plaintiffs. Something like 30% of cases are on behalf of defense. So I know it from both sides. So if you're representing the plaintiff, this is what I recommend. Look for biases that might cause the defendant to make bad decisions that harmed your client, like with Officer Schuler. Demonstrate that the defendant did not take steps to learn about the biases. Officer Schuler did not take steps to learn about these biases, especially when he did not abide by the departmental procedures, which were in part meant to address the kind of biases that we all naturally tend to suffer from. Support your case of the defendant's liability and protect your own client from claims of biases. So look for potential areas of vulnerability in your own claims, and figure out how you might protect it from accusations of bias. How about the defendant? Thinking from the perspective of the defendant, look for biases in the actions of your client. And anticipate and address claims of bad decisions. Try to demonstrate how the defendant took steps to address the biases. So the city of Annapolis took steps to address the inspection regime by not inspecting as stringently the public housing as it would have for private housing. Reduce the likelihood of your client being held liable by looking for biases in the claims of the plaintiff and showing how the plaintiff made bad decisions. So how the plaintiff, for example, is only looking at the group who are current residents and completely ignoring the larger group of people on the waiting list who are comparable in their minority status and their protected status, and completely ignoring this. So that is a serious problem from the perspective of the plaintiff, that the accusations they're making. So I hope this has been illuminating. For free additional resources, as I mentioned before, if I'll be happy to meet with you to talk about these and help you integrate debiasing into your own work. First come, first serve, 3 coaching sessions open. Then I'll send you 2 copies of my best-selling book, Never Go With Your Gut, How Pioneering Leaders Make the Best Decisions and Avoid Business Disasters, and The Blind Spots Between Us, How to Overcome Unconscious Cognitive Bias and Build Better Relationships. And I will also send you the expert witness reports that I showed you when I was doing this presentation. Now, again, if you're here, don't worry about it. We'll send them to you automatically. If you're watching this as a recording, to get these resources, go to tinyurl.com/DAEEVENT, which is the link under my name. That's tinyurl.com/DAE event. Again, that's tinyurl.com/DAE event to get these resources. And I'll be happy to take any questions you have at this stage.
Hey, folks. Yeah, we've got some time, so please do ask your questions. We Dr. Gleb, maybe you can talk a little about some of what you wrote about in the article about making the system more fair. You talked a little about how depending on which side you're on, there may be some strategies, but what about just trying to get biases out from where they don't belong? I mean, is that
Yeah, definitely it would be great if we can do training. So talking to the individual lawyers here, but from a systematic perspective, if we have judges, regulators, if we can do more training for folks on debiasing, and if we can introduce checklists into looking for biases in the judicial procedures, give some instructions to the juries. So there's definitely lots of stuff you can do if you actually have some impact on the system.
I'm curious, as you mentioned you do some expert witness work. Is this something you have you heard, judges or attorneys talking to juries about, the risk of bias and as just something people are leveraging on one side or the other, depending on which side of the case they're on. I mean, you would hope that there'd be kind of a neutral in there that giving people a warning about the dangers of, we're implicit bias or whatever. Anyway, I'm just wondering what your experience is with that.
It's pretty rare. I don't think judges are sufficiently knowledgeable about this topic, and this is definitely a challenge that I think it would be great if judges did more of this. But usually I tend to see it on one side or the other, and people who are the lawyers who are more savvy and who integrate this into their work are the ones who tend to be more successful, of course. But it would be nice if the judges were, if it wasn't only lawyers providing education to juries about this topic, and if ideally, of course, there would be lawyers on both sides who are familiar and cognizant of the concepts of biases, and they would be able to create this competitive pressure, which helps provide neutral education from both sides in this topic.
And I'm curious because we do have a big group here today. If people have any experiences that they'd care to share or observations on how this might work in Vermont. I mean, we are famously not a terribly diverse state. Uh, anyway, I just what do folks think? Is this a problem that we don't have here because of our relatively homogeneous population? Jeffrey had a question there about limiting. Can you see that, Dr. Gleb?
Yes.
Yeah.
So, yeah, I've never heard judges giving limiting instructions on bias. So it would be, as Kim mentioned, would have been good if judges provide some education for that. But hopefully this is something that judges can get some training on. That was part of what I talked about in the article. So
Yeah, I think, certainly it is a topic that I think our judiciary here in Vermont is concerned to address, but I don't know what's really happening out there. And I've been doing this for a few years and not in court so much, but which is where I think this is where the rubber probably most meets the road, where there's a contested case of some kind and somebody's trying whatever. I mean,
mhm,
you have two sides
of
trying
course.
to say the other side is wrong about something or bad or whatever.
Mhm.
So anyway, any other observations or comments from folks on this?
If you
Don't be.
folks have no more, if yeah, I can also share some more of the expert witness work that I did. I shared two things because I want to make sure to leave plenty of time for questions. But if people don't have too much time for questions, I'm happy to share more examples of different cases.
Okay, Denise just popped something in there. Maybe that's
Mhm.
something to address there.
Okay, negotiations, mediations. Yes, I definitely think I've been part of arbitration, not negotiation or mediation, where bias was definitely something that I talked about as an expert witness as part of arbitration, where I was brought in to talk about this issue and how it was involved. So I imagine it can be used in negotiation, mediation, where you can bring this up and have these awareness and conversations.
I wonder if you've heard lawyers going back and forth on that. I mean, actually, it would be interesting, especially if they, read your book or taken the course or whatever. It's like, well, this halo and horns effect. I thought that was an interesting discussion. I mean, just human nature. Yeah,
Mhm.
I'm being told that's biased by one of my colleagues here. Um, yeah, I mean, it is, but if you get
Yeah,
called out on it, like while it's happening, I mean, maybe you can address it. I don't know. I just, you know,
yeah, it tends to. So I think it's not yet sufficiently present. Let me say it this way. Generally, the lawyers on the other side of cases that I have been participating in haven't had another expert witness who talks about bias, and they don't have that much expertise on it. So it tends to be a losing proposition for them to really go back and forth on it. And so they tend to just focus on other things. That's been my experience.
oh, right. Okay. My colleague said I wasn't being biased. He was talking about something else. So I'm curious for you. So you've been called worked as an expert witness on both sides of these cases. And did you say that in those cases the competing side didn't have their own expert to deal with the same issues, or were you the
Yeah,
only expert?
generally when they had experts, they would have statistical experts. So, not not psychological experts. So they would talk about, well, here are statistics and here are statistics. So here I'm going to challenge your statistics with my own statistics, let's say something like that. But when you talk about here's the psychology involved, there I haven't been confronted with an opposition who talks about the psychology of the issue in any sort of significant way, because it's hard to. I think I don't take on cases where the argument would be losing. So
Right. I see. Yeah, no, that's just if one side has an expert on the topic, it seems pretty common that the other side would have a similar expert. But anyway, yes, we do still have a few minutes. So folks, think if you
mhm.
have questions, if you want to talk a little more, because we do want to, we
Yes,
want our hour. So talk a little
sure,
more about some of your experiences, that would be great.
absolutely. Okay, so so this is from another area, from employment, obviously an important area for employment law and bias. So this is someone who was claimed race and disability discrimination and retaliation and resulting emotional harm. So she's an African American adjunct instructor with documented cardiac limited limitations, requested online teaching. Despite available courses and her qualifications for them, she was denied or given minimal assignments while non-disabled and white colleagues received favorable treatment. After internal complaints, she faced negative shifts in supervisory interactions. There were dismissive and sometimes hostile responses. And so, looking at the situation, I found pretty clear evidence that Ms. Chapman was subjected to arbitrary and capricious evaluation processes where white faculty were favored in course assignments and performance marks. And in fact, the university itself admitted the evaluation outcome was improper and should be expunged. And so when you look at best practices, there's a clear and equitable evaluation structure, but her scores and statements by her supervisors reflect possible racial stereotyping and horns effects. So we talked about the horns effect as an example. And there was a failure to accommodate as part of this. So we talked about it's hard to know whether it's white or disabled, but she requested additional online courses instead of in-person courses. Instead of offering alternative solution, they didn't even engage in the required interactive process. They just denied her requests. So in fact, the university lacked a formal accommodation process prior to her complaint. They only created one after receiving the EEOC complaint. She also had marked scrutiny from senior officials after the filing of the EEOC charge. This was retaliation. And her teaching responsibilities were disrupted, and so on. So this was a pattern of adverse treatment that would dissuade a reasonable employee from engaging in further protected activities. And so this is a typical example of disability and racial discrimination and/or racial discrimination. And so looked at all of these elements, gave some specific examples, documents. So here are patterns of discrimination focusing on how white instructors typically referred preferential assignments. So gave some examples of this and gave some examples of what was going on. So this is an employment discrimination case. And this is something that folks need to really be aware of, that whether it's disability discrimination or racial discrimination, the preferential assignments, that opens you up for various sorts of problems. Okay, I see we have a couple of more questions came up. So, Kristen asks, are you familiar with the concept of white fragility? Yes. And if so, have you ever seen this or a similar reaction from juries, opposition, etc.? How do you deal with those reactions as the advocate? So it's a difficult issue where you want to be aware of what's going on, and focusing on the protected status of the person, the African American, presumably, here is what you want to focus on, that this is the law, that disparate treatment is discriminatory, that is something that is illegal. And so if you can, regardless of what people think about white fragility, there's the question of the relevance of the facts here. So are we looking at the facts? And if we're looking at the facts, are you looking at the disparate treatment? So focusing on what the trier of fact needs to actually figure out. Was there disparate treatment or was there not disparate treatment? Disparate negative treatment for people who are Black or people who are disabled? Was there, if you have accommodation, was there actually an accommodation process or was there not? And if you find that there's disparate treatment that's negative for people who are protected, that's all you need to find, regardless of whether white fragility is there or not, regardless of what's going on, regardless of political polarization. Now, of course, you can't always take it out of the people will still have their personal political beliefs, and this is something that you might want to do during jury selection to evaluate these sorts of questions to make sure that the jurors, and that's part of something I do, I help with jury selection. So what kind of questions do you want to ask the jury to vet them? But once, you can't always control what the jury thinks, obviously. So you want to really focus them on what are the legal matters and what they actually have to find. Yeah, so Timothy asked about the psychological impact of discrimination on people who are victims of bias. He's known people of color working in Vermont who expressed how hard they find it to work in the state. They experience debilitating anxiety. Yes, absolutely. So let me go back to something that I already showed, but go to another element of it. So I'm going to go back to the report on the killing of Mr. Henderson. And part of the report, I didn't talk about this here because again, I want to keep it limited to the hour, but part of the report was explaining what's going on with Mr. Henderson, namely why he drove away, explaining his anxiety. So this is historical trauma and PTSD in Black communities due to systematic and aggressive policing. And so you have, and it's due to aggressive policing, but this is part of the broader concept of debilitating anxiety due to racial discrimination. Historical and systematic racial discrimination, particularly regarding interactions between African Americans and law enforcement. And again, this is not simply due to law enforcement, this is systematic bias. I focused in this case on law enforcement, but this is more broadly applicable to systematic bias. So here there's research that African Americans have endured traumatic interactions with law enforcement for more than 400 years, tracing back to slave patrols and so on. Such violent policing practices have been instrumental in perpetrating intergenerational trauma, creating an enduring psychological impact that persists across generations. And this is all cited in the references section, which of course, very important for the expert witness report. So he talked about how modern policing practices leads to widespread psychological stress, the higher numbers of African Americans shot, routine stops causing anxiety, African Americans sustaining injuries from police interventions at 4 times rates greater than white individuals. And that systematically elevates mental health risks among African Americans. So Black individuals who had interactions with police exhibited nearly double the prevalence of PTSD, anxiety disorders, and so on. Even routine encounters have been shown to produce severe psychological trauma. And so this pervades daily life for African Americans. There's the talk where Black families teach their children survival strategies, reflecting internalization of trauma and the cultivation of a heightened continued sense of anxiety. And in fact, Mr. Henderson called his mother while he was stopped during the traffic stop, and she was on the phone for 15 minutes with him, including when he was shot. And that was pretty traumatic for her as well. And this is part of the case. And so these are serious issues, and it's not only due to policing, but more generally, the experience of systematic racial discrimination is part of something that causes Black people to experience anxiety.
Okay, I don't see any more questions coming in for you. I mean, I guess as I'm listening, I think just the consciousness raising of bias is an important part of trying to deal with it. As you're talking and listening, thinking myself, if I've been guilty of halos and horns for people, probably I have. So, so I appreciate your talking to us all about this today and sharing your expertise. And it looks like everybody on the call will be getting your more information from you. Hope folks will find that useful. Thank you, everybody, for coming today. My colleague Laura did drop a link to Dr. Gleb's slides there, but I guess you're going to get those separately as well. And we did record the program. So thanks, everybody, for coming. Please do have a look at your CLE calendar for June. We've got Procrastinators Month. It started as Procrastinators Day. Before my time here at the VBA, it became Procrastinators Week, and now it's all month, but not that all of you are procrastinators. Thank you, Allison. Nice comment. Thank you for this. And thank you for the program, Dr. Gleb. So folks, thank you for coming today. Do have a look. We got Real Estate Law Week next week. If real estate is your bag, we've got 6 programs next week and a really interesting wellness program on from our popular presenter, Cassie Gillespie, of a licensed social worker, trauma-informed stuff. Anyway, everybody likes her. So, okay, I'll let everybody go. Thank you again, Dr. Gleb, and we'll see you at the next CLE. Bye, everybody.
Thank you. Bye-bye.